Good morning, distinguished speakers, delegates, ladies and gentlemen. It's my pleasure to welcome you to Day 2 of the Kuala Lumpur International Arbitration Week 2005. And one very important, this is our flagship conference, the I-Arbitration conference. Now, in yesterday's, Professor Doug Jones' Centennial Lecture, he touched on the importance of looking back to look forward. This statement carries the right balance of pragmatism and value. Every person, every market, every industry, every organization has a backstory, a tale of how things began, a journey filled with challenges and triumphs. We always learn from our past, I hope, because those who fail to learn from their past are actually fated to repeat it. So we learn from our past, and only once we truly appreciate and respect our origins can we move forward. And how is it that one moves forward? How does one progress and develop into something greater? I think you really have to work hard. I think that's the first thing. And you have to broaden your definition of authenticity, and also you have to innovate. This conference actually has its roots in the publication of the I-Arbitration rules, which we introduced in the new I-Arbitration rules, which we introduced in 2012. And innovation was the key that led to the inception of the rules. And the word will continue to play its part in today's conference, entitled Islamic Commercial Arbitration, Innovative Resolutions. For those of you all who are yet to acquaint yourself with the term I-Arbitration, please allow me to actually say a few words about the Centre's award-winning Sharia-compliant product. I think we have the experts there. I hope it is Sharia compliant, but which we introduced officially to the world at the Global Islamic Finance Forum back in 2012, and its contribution to the global Islamic finance scene. The Islamic finance emanated in its contemporary form during the 1970s, and over the last few years it has boomed robustly because of economic growth and also the shift of activity and wealth to its core markets. And I think that core markets have been Southeast Asia and the Gulf area. So moving in similar upward trajectory, which I discussed yesterday in my speech, is the notion of ADR, particularly arbitration, which is now gaining traction and becoming an essential part of dispute resolution fabric in Asia. It is widely acknowledged that there is an expansion globally in terms of commercial transactions based on Islamic or Sharia principles. And the Islamic finance industry is already a large part of the world economy, evident by the fact that the industry experienced double-digit growth of 21% in 2011 and continued to average a growth of 16% in the following 2 years in 2013. I think the world economy has been going through some challenges, especially I think in the Gulf, and even in Malaysia we've been having issues of oil prices. Low oil prices, commodity prices being very, very low. It does affect the way funding is done. You know, when you have a lot of money, you tend to borrow even more. When you have less money, people are quite reluctant to lend you. They ask you for higher rates. You know? So I think that's basically a truism that's always there. But you know, I think you know the thing is that the pundits are all very, very optimistic. And Islamic banking and finance is projected to exceed 2.5 trillion of assets in 2015, while the industry goes into new markets. And if we break down the schematics of the pie of Islamic banking, is most likely to represent a share of 86%, I mean about that, and of the 2.5 trillion market in 2015, followed by Sukuk, the Islamic equivalent of bond, at 6%, Islamic funds at 4%, Takaful, Islamic insurance at 2%, and Islamic microfinance at 1%. I mean, these are figures we just extracted from published figures. I don't know how good the research is. I suppose that is what we have. I think one thing is that we in Malaysia are blessed. We are blessed because actually we have been recognized as a pioneer. We are actually some good thinkers and innovators, and we have been recognized. And I would attribute that to my former employer. I used to work in the Central Bank of Malaysia for 18 years before I left. But I didn't work in the finance section. But when I worked there, I always had this pride that the Central Bank of Malaysia were pioneers, on a lot of things. There were a lot of ideas developing. They were always trying to develop and grow the financial system. While the conventional system is there, they were always trying to leverage on what we could do. And being a Muslim majority country with a diverse plural population, it is a very ideal place to actually carry out such kind of experiments, because to tie back the convention banking system, finance system together with the Islamic system. And then, in fact, I still remember Tan Sri Noor Mohamad. He was a forex dealer. And in fact, we lost $5 billion US. In fact, he had to resign because of that. But I think in one of the things that he was actually coming out with was actually Islamic finance, how to do this, how to remodel the idea so that it becomes Sharia compliant. Because you need to have people who actually know the conventional business, at the same time move to the other side. Of course, I think, and you do make mistakes sometimes, but it doesn't mean that it all goes wrong. So I think it was because we have been a pioneer, and the system is quite well developed now, especially the Islamic financial system. It is only natural that there was a call for a set of dispute resolution rules. There was always, when you have the, let's say, a parallel system that goes in, then you have to set up a system of dispute resolution that will facilitate that the resolution of disputes in that system. So I think, what I want to say is that we have a lot of experience in Islamic finance. And one of the things that actually happened then is that the central bank and the Securities Commission, being regulators, also set up what is called the Sharia Advisory Council. I think that was actually a very, very pivotal move to strengthen the Islamic finance economy. Because I think one of the issues that always come is whether it's Sharia compliant and who decides that. And then so that's why they had these Sharia Advisory Councils. And the Sharia Advisory Councils, although the legislation is quite determinative in the way it says that the advice or the finding or almost the fatwa of the Sharia Advisory Council is binding on the tribunals that have to deal with this issue. I will say something how we try to overcome that, and then together with that, they set up the Mu'alamat division of the High Court. So I think on one side you had the banking sector pushing Islamic finance in a very, very big way and setting up a advisory council structure. And then on the other side, they set up in the court itself a special division to hear Islamic banking cases, and it was created in 2003. And I think, this already suggests that the people who were structuring the system were very, very cognizant. There was actually a need for dispute resolution. But the interesting part of this approach is that it is domestic. But when you look at Islamic finance, it is not domestic. You raise money overseas. You deal with outside parties. And when you enter into contracts with outside parties, a domestic system has limitations. I don't think so. A person who basically invests in an Islamic finance derivative or instrument will be prepared, let's say if he's from Bahrain, to come to a Malaysian court. Okay, then the other thing also is the idea of the jurisprudence. We always think that that the Islamic faith is of one monolith arrangement, but in actual fact, we suddenly realize the schools of jurisprudence actually it depends where you come from. I have to say that, you know, almost it depends where you come from. If you are from Malaysia, it's Shafi'i. But if you are from the Middle East, it depends again where you come from. Let's say if you come from Iran, it's a Shiite. And even among the Sunnis, there's 4 schools, Hanbali. I mean, I'm just saying, so it's a bit more complex, especially when you have to deal with the Sharia and the legal principles related with it, because different schools look at it differently. So we were actually asked to deal with this. In fact, Bank Negara, I must say, pushed us. And we are quite appreciative of that, because sometimes you need some pushing, some encouragement. And then what actually happened was that we then came out with the I-Arbitration rules. The I-Arbitration rules was actually built up on a previous set of rules, which is called the KL-RCA rules for Islamic banking and financial services arbitration, which applied only domestically. Again, you know, it's all these ideas all started domestically. And then what we did was we then came out with the I-Arbitration rules. And our keynote speaker, Mr. Thomas Kutzel, is going to actually explain to you all in detail. And he will venture, I suppose, an analysis of how it works. But I will say something. When I first had to deal with it, I was grappling with the idea that I don't understand the Sharia. But when, let's say, and I'm assuming that I'm sitting as an arbitrator and I don't understand Sharia, how, and then if we look into the system itself, the instruments, the Islamic finance instruments are all very, very highly specialized, highly complex. And they are actually very, very basically commercial contracts. Commercial contracts that I think a lawyer would understand it very well, or perhaps may understand it, but they are complex at all. But to resolve that issue, you have to go to people who have that kind of expertise, who can handle complex commercial contracts, isn't it? So we have to bring the Islamic finance and all these instruments into the international arbitration framework, commercial framework, international commercial framework. That's what we try to do. And the I-Arbitration rule is an attempt, in fact, I think it is the attempt to deal with this. So the entire idea is this: we will have a impartial, a neutral panel of arbitrators who most likely or may not have any expertise in Sharia, but they are experts in the contract, resolving contracts, international commercial arbitration, and all these things. So we also see non-Muslims being involved, people of the highest expertise, Muslims also, but drawing into the entire network of the world that's already existing, the expertise. So what we did is, how do we deal with the issue of Sharia if it comes up in the arbitration? And that's where Rule 11 came in. Rule 11, before that, under the 12, I think before we amended in 13, in the 12 it was Rule 8. It is actually a very simple concept, and I always say that, you know, the most difficult things must be solved by the simplest of ideas. And already, I think, you know, what was the most important thing that guided us? That we thought that when there is a dispute, you need to get the best people to do the work. That's the first thing. That means you must not shut yourself up to only a very small group of people. Let's say we made it a Sharia arbitration, then what you're going to get is only the ustas or the learned people in Islamic law who will sit there and decide. But they will not know complex commercial law arrangements. So I think that was not on. So we said we will look at this way, which I've already explained. The second thing is that, how do you handle Sharia? Sharia, we said, and we looked around and we realized that the law in the system was already handling such things. And they handled it by looking at law as a distinct discipline and saying that this is, if you, let's say, we have to deal with it, you call it foreign law. So we decided to also do that. What is the overriding intention of all this? Is enforcement under the New York Convention. The New York Convention is the most successful convention. It allows for cross-border enforcement of foreign arbitral awards. And that is the thing that I wanted very much to tap into. Once you can actually enforce an arbitration award that comes up from this use of these rules in any country which is New York Convention, who has ratified the New York Convention, that means you have universal enforceability cross-border. Then it is going to work. The other thing is, how far do you want to bind the arbitral tribunal on the decision? And we use either the Sharia Advisory Council or any advisory council, any Sharia Advisory Council relevant to the dispute or the school of jurisprudence, or a Sharia expert. That's the way we dealt with it. To what extent that opinion should be binding on the arbitral tribunal? It's very, very interesting. In fact, the Central Banking Act Section 56 suggests that the opinion of the Sharia Advisory Council is binding on the arbitral tribunal or even on the High Court, which is very, very interesting. In fact, I think we have split away from that. In our rules, we say it's not binding. It is actually an opinion, and it is for the arbitral tribunal to actually decide on the merits. So I think I've now given you all the thing. You know, one of the proudest moments in my life, being in the center, is when we finished these rules. We won the GAR Award, which is the Global Arbitration Review Award for innovation by an individual or an organization. That was one of the proudest moments of it. So I think, you know, the international community, I think, of course, the deep analysis is going to come from Thomas. The international community accept this set of rules will work, and it is actually something that is workable, and it's something very innovative. So I think if I can conclude by saying is that today is only a discussion, starting of this discussion. We set this thing up so that you can actually delve into it in greater detail. We have brought a lot of experts. I've actually asked Thomas to come here to talk about and give us, because he is one of the very few persons in the world who has analyzed our rules very, very deeply. And then I've got other people to talk about various other aspects of Islamic finance and how it relates to dispute resolution. With that, I hope that you all will have an enjoyable time. We have two streams. I'm shuttling between here and there. And in between, if you don't see me here, please forgive me. I doubt that I'm not interested. I'm very interested, but thank you very much for being here. Thank you again.
Thank you.